So Karen is going to cover these quickly, and then we're going to breeze through the recommendations and be done hopefully in about 5-10 minutes.
So this is actually an issue in special ed all the time, where a parent says they want to see the students' test protocols to know if you say my kid is learning disabled, I want to see the question and the answer that my kid gave instead of just taking your word for it. And it's an interesting issue. This is a lawsuit where a parent demanded under the California student record laws the tests themselves, the protocols, and the answer sheet. And basically the parent wanted to go back through and regrade the test. The school then went to court and said, hey, judge, don't make us turn this stuff over because we think we would be violating the copyright law. And the court said, in this specific case, we were trying to educate the parent to help the parent understand that their kid actually was learning disabled, that could fall under the fair use exception. The parent didn't want to get the test protocol so that they could sell them. They wanted it for an independent education evaluation. The court said normally test creation is strongly protected, but in this case, the court said the school could give the parents only as much as necessary to understand that the student truly was learning disabled. I will tell you that there's a crap ton of special ed cases that have gone the other way. Most hearing officers will not order schools to release test protocols that are copyrighted. My best advice is if you have a parent that demands the testing protocols, I would sit down with them and talk through the fact that we have copyright issues. I'd get your lawyer involved sooner rather than later, because we want to make sure, because this is one of those that you're going to get sued if you get the wrong answer, no matter what you do, right? Giving it to the parent, you get sued by the testing company. Not giving it to the parent, you get sued by the Department of Ed, or you get a complaint from the parent. So there are a couple of cases that allow the testing protocols to be given up, but for the most part, most of the courts have said, or hearing officers have said, you don't have to give the entire protocol. Here they said this is just one time, it wouldn't have a widespread effect on the market, but if that's true, it's going to be true, across. If everybody has to do it, then it will have an effect on the market. This is interesting because we had a personnel hearing this summer about what the protocols are about the NESA tests. If a teacher has students copy down the questions for NESA, not only is that an ethical violation, but technically that's a copyright violation because the Department of Education in Nebraska owns the copyright to all those questions. And this is exactly that case. This is a teacher that worked for Chicago that thought standardized tests were stupid. And so in his little underground newspaper, which was called Substance, he published the questions that were on the Chicago standardized tests, not really so much to make money, but to say, look how dumb standardized testing is. The court said, in general, we want to encourage people to have a robust discussion of political issues and whether or not standardized testing is good. But dude, if you publish the test, you're going to destroy the entire value of these limited access norm standardized tests. It would completely destroy the value to Chicago if we allowed you to do that. And so in this case, they said, Mr. Teacher, you can't publish these tests, not because it's illegitimate for you to have a political opposition to standardized testing, but because you would take away all the benefit that Chicago, they'd spent millions of dollars getting these tests to a place where they were norm referenced. We're not going to take away the entire value of the testing system. So fair use doesn't apply in this case because it would undermine the entire value of the test. This is just a funny little video about fair use, and it's like, it's a fairy tale characters trying to use fair use. It shows you how stupid lawyers are because we were entertained by it, so we thought we would share it with you. I don't know if you'll be as entertained as we were, but we were. So there you go.
Okay, the question we had come in for the collage where students are adding their own pictures and things. In some cases, they're using photos, for example, photos of Husker games or the Pittsburgh Steelers or the Kansas City Chiefs, so that other students will understand, oh, we both like the Kansas City Chiefs, which I think you can try to weave some educational purposes into that, right? Kids to learn more about each other, but I'm still a little bit worried about the extent to which if a kid is Googling that off the internet and taking the best picture they find, it's probably owned by some news organization who paid that photographer or by that photographer or by that team. So it's not ideal, but if they can find the grainy cell phone picture that some random fan took, that's better than the clearly professional picture that somebody from a news organization took. But I think if you can tie some sort of reason for it, like for example, kids are going to look at it and know each other better, then we've got an argument.
I also probably would would encourage Creative Commons, to use Creative Commons here. Now, Creative Commons is not a solution, because it's not a one-size-fits-all solution, because if I rip somebody's photograph off and upload it to Creative Commons, that doesn't mean that the person that took the original photograph doesn't have any enforcement ability. But remember, the more good faith you're engaged in, the lower the damages, or we can even zero out damages. So if we're using Creative Commons and we're relying on a representation that this is copyright free, and the person that took the picture has said you can use it, then I think you have a much better argument for reasonableness. Then also, that can be an educational purpose, because we're teaching kids about respecting copyright. And so that gives us another defense. So I would try to use either OER or Creative Commons, something that we would at least have a representation from somebody that this is in the public domain.
So real quickly, there are multiple types of license, right? When you're talking about a radio broadcast, you've got 4, 5, 6 different types of licenses that could be available. So think of a graduation ceremony. If you've got a band performance, you've got mechanical, arrangement, master, performance. If you set, Green Day, Good Riddance to your slideshow at graduation, you've got then the reproduction of that work, distribution, broadcasting, possibly performance if the choir's going to sing it. And if you're selling copies of the videos that you took at the band performance, you're posting them on your Stride, you've got even more licenses. So again, I think the thing to do if you're worried about this stuff is ask the person that you're getting the music from what it actually covers, because if that's not clear to you, you could have paid for a license that doesn't actually cover what you need. I think that you should do a copyright audit and inventory at some point. So whether this is as part of your PLN or something, but essentially have a spreadsheet or some document that has 3 columns. Ask every teacher to put the materials that they use in class, which they did not create. Then have a little check mark for if you know that the school bought it from Houghton Mifflin, that's great. We probably got a license for it. If not, the 3rd column should be the copyright exception. So Gone with the Wind showed as a reward versus Gone with the Wind showed as part of the academic experience. Your staff would then know, or you as the building administrator would have to think, okay, which of these is it? And it at least give you a way to, again, hit that reasonable belief that we weren't violating copyright laws.
Hold on just 1 second. We should create that form and share it.
Karen's going to create that form and share it.
I'll create a Google Doc and share it with the world. I'll put the link on the website, because it would be helpful to have it for us too.
And again, that would be, then it's something for you to give to your staff, but either way.
Then I will let you use it under a license, and then I will not claim copyright for it.
And again, be thinking about, we didn't talk specifically about dance team, but you got the same problems there, right? It's from the teacher's iTunes account, and they play that music. I mean, that's still limited by all the other things we talked about. So again, I would include then your sponsors in this. That's the point.
Yes.
Provide copies of that circular if you haven't. That's at a minimum the classroom use stuff, and I think it's easy to do, and it contains a lot of the stuff Steve talked about for movies and music as well. You've got the circular, distribute it. It outlines the maximums, talks about things that you can do, gives at least some objectivity to it. And with that, despite our technical difficulties, we are 1 minute early. So any final questions?
Yeah, any final questions? I'm checking texts. Thanks guys for sticking with. We did record this, so if you can get through the first couple of crashes, it would be available if you want to review chunks of this with your staff. And then we are going to send out a questionnaire to ask about how you went. You'll notice we did this different. We sat this time, and I'm real curious. We truly crave your feedback on this, so let us know what your thoughts are, if this format works for you, and what we can do to make it better.